This conference will now be recorded.
So if you haven't done so already, please mute your microphones unless you want to talk. And that way I think the presentation will be a little bit smoother technologically, hopefully. So to start off my first slide, I want to note that the date's wrong. This was going to be presented to the City Council on November 4. We rescheduled it for this evening for both the Planning Commission and the City Council. And I want to give thanks to Steve DiGiulio and Adrian Winder of Foster Garvey. I, with them, did a presentation through the Association of Washington Cities about a year ago, and I've used some of the slides from that presentation for this presentation. So let's get started with the Open Public Meetings Act. The Open Public Meetings Act was passed in 1971, and it applies to all public agency, legislative bodies, boards, commissions, committees. It does not apply to the courts, and it only applies to the legislature to a limited extent. But there's a very strong message in the intent and the purpose of the act, and that is that the people of the state of Washington insist on remaining informed so that they retain control over the instruments that they have created. So why are we here? Why am I torturing you with this presentation? Part of the reason is that in 2014, the legislature amended the act to provide that Open Public Meeting Act training and public record training is mandatory for all members of governing bodies, boards, and must be completed every 4 years. If you're a new member to a board or commission or council that is subject to the Open Public Meeting Act, you must receive your training within 90 days. And so we are keeping a roster of this training so that we'll have a record of your attendance at this training that we'll be able to keep for you. So going back to the intent and the purpose of the act, again, the act provides that meetings are declared to be open and public. All meetings of the governing body of a public agency shall be open and public, and all persons shall be permitted to attend any meeting of the governing body except otherwise as provided in this chapter. So for lawyers and for you, the definition of the words that are used in the act are critical. It's all about the definitions. So let's start with the definition of a meeting. And I want to tell you that I think we'll have plenty of time in the hour that we're devoting to this, that if you have a question, go ahead and unmute your mic and ask the question during the presentation or at the end of the section on the Open Public Meetings Act. I'll have a slide asking you if you have questions, and the same thing will then go to the Public Records Act, and I'll ask you for questions there. But if you do have a question, please feel free to speak up. So a meeting is a meeting where action is taken. So it's not just if a quorum of the commission members or council members are present in the same place, that doesn't in of itself constitute a meeting. But the word action for a meeting is a meeting where action is taken. Action is described very broadly. It is not just the making of a motion and the taking of a vote, but it includes everything from the receipt of public testimony, your deliberations, discussions, considerations, reviews, evaluations, and final actions. So it's really hard to imagine much that you would be doing when you're engaged in the business of the city that wouldn't be one of these things in the description of action. Particularly discussions and deliberations are very broad terms. So if we've got a quorum present and you're just talking about the Seahawks debacle last Sunday, that's not a meeting. You're not discussing city business, but if you are and you have a quorum present and you are talking about city business, you are having a meeting. So meetings don't require members to be present in the same physical location or even interacting simultaneously. So as you all know, with COVID, we have now moved into a pretty much a virtual world, which is, it used to be pretty unusual to have all council members participating by phone or a Zoom or GoToMeeting software, but now it's become pretty common, everyday kind of occurrence. So the slide might be a little bit dated because we have moved into a new world, but conference call, with a majority, that's a meeting. Something that you really need to be aware of is if you're doing an email exchange about city business, that includes a substantive input from the majority of the body, that is a meeting. And so we call them serial meetings, where you might have an email from member A to member B, which is then passed on to member C. And you get a discussion that maybe when a council, you have 3 people in the email chain and you're talking about city business, or the same thing with the commission. If you have a quorum there of 3 people and then you're exchanging emails about a subject, you are engaging in a meeting. And that is certainly not a very open meeting because nobody else knows it's going on. So the one difference is just receiving information without having discussion is not a meeting. So with the case of council, I will sometimes send out an email to all members of the council and saying, I want you to be aware of something, but you'll note I invariably put at the end of the email, please don't use reply all. So I can convey information to you, you can receive it. I can do that to all council members or all commission members, and just that passive receipt of information is not a violation of the Public Meetings Act. But if you reply all and you say, well, what about this? And you should think about that, then we have slipped into the realm of engaging in discussion or consideration of city business without having an open meeting and violating the act. So meetings are more than just our formal council meetings on Wednesday nights or planning commission meetings that are regularly scheduled. Meetings can include business meetings where if you get again, a quorum present to meet about something and it's outside your regular meeting time, you're still engaging in a meeting. A workshop's a meeting. Public hearings obviously are meetings. Retreats, those are meetings as well. And so all these have to be open and available for the public to attend. There's some things that are meetings that are either not covered by the Open Public Meeting Act. An example would be a meeting to discuss collective bargaining negotiations and related discussions. The legislature specifically expressly provides that those are not subject to the Open Public Meetings Act, and some quasi-judicial hearings. Normally, these are done by state agencies And they're covered by the Administrative Proceeding Act, and they're not subject to the Open Public Meetings Act. So going back to, did we just inadvertently have a meeting? Did we engage in the phone call, email, text exchange where we're discussing city business? The Open Public Meetings Act does provide that travel and social gatherings or events are not subject to the open public meeting if no action is taken. So let's talk about that for a minute, because it does come up. I mean, you're engaged in the community. You probably find that you're at a event where there's a majority of the commission or council members present. And it wouldn't be unusual for there to be some discussion about city business at that event. And so how do you do that without violating the Open Public Meetings Act? And the answer is you can't. I mean, if you're present with a quorum of your commission or your council, and you together engage in a discussion of city business, that is engaging in a meeting, because that broad term of discussion or deliberation or consideration. So my advice to, I know members from experience that they want to go to these events. They don't want to be barred. They don't want to have a policy that only 2 people can go to such an event. And so what I encourage them is just, that's fine, go, but avoid having a quorum sitting at the same table. And sometimes the way these things are arranged, maybe they'll have seating where they put council together or commission together, but it's better to just not have more than 2 members at the same table, because you can almost bet that there will be some discussion of city business going on during the event, and you don't want to have an inadvertent meeting and violate the Open Public Meetings Act. One other thing to be careful of is sometimes during a meeting, it seems that people might be texting, either constituents or each other, or engaging in some text messaging during the meeting. And again, that is consideration or discussion that is ongoing outside of the open public meeting, and that is not appropriate. It is not legal. So avoid engaging in either texting during any meeting where you're talking about city business in the text conversation. So what's a meeting? What's a governing body? Again, the act applies to meetings of the governing body. But the governing body includes not just the council or commission, but also committees of the council or the commission, if it's acting on behalf of the council or the commission, or if it's conducting hearings or taking testimony. So you can have committees, but again, if they're a quorum of the body and have the authority to act on behalf of either the council or the commission, those meetings need to be open to the public. So again, talking about committee meetings, a committee acts on behalf of a council. If all that the committee is doing is providing advice or recommendations, but not taking action, doesn't have the authority to do anything, just can come back and say, this is what we suggest, or this is what we advise, that's not acting on behalf. But where it exercises, again, some actual decision-making authority, then if there's a quorum, it's a meeting and it has to be open to the public. And one thing again, even though a meeting of a committee may not be technically subject to the Open Public Meetings Act, you can have the committee subject to the act as a matter of policy, that we just want to make sure that the public knows about our meetings and that they're open. And that's, it's completely appropriate and frequently is adopted as a matter of policy. There are some organizations, some nonprofits that end up being subject to the Open Public Meetings Act because they are what the court calls the functional equivalent of a public agency. And a couple examples would be the Washington Association of Counties was determined to be a public agency subject to the Open Public Meetings Act. Association of Washington Cities, the Washington County Risk Pool. There's a case called Telford, and in Telford, that's where the term functional equivalent of an agency came from. And what the court looks for is, does this organization perform a governmental function? How much of its funding is provided by the government? What's the extent of the government involvement? And was it created by the government? And looking at those four factors, you don't have to satisfy all of them. It's sort of a balancing of the factors, but there are situations where even private entities are subject to the Open Public Meetings Act. So we have two common types of meetings. We have our regular meetings, which are meetings where the time, date is established by rule or ordinance. And then there's special meetings, which are called as needed, not at a regular time or place or date. And there's a third type of meeting, which is an emergency meeting. It's a little bit different. So the emergency meeting is a meeting that occurs when there is, in fact, an emergency. And the typical example is a natural disaster. And if there is an emergency and it requires immediate action, you can hold an emergency meeting without any notice. Regular meetings, we have notice because they're established by rule or ordinance. Special meetings, we have special notices that we'll talk more about. Emergency meetings, again, there's not a requirement of notice, except that you should try to provide the same type of notice that you do for a special meeting if it's practicable. As I said, regular meetings established by ordinance, bylaw, resolution, rule. Special meetings. Special meetings can be called by either the presiding officer of the body or by a majority of the members. What we have to do for a special meeting is provide 24-hour notice to board members and the media. You have to include the time, the location, the agenda, prominently display a notice of the meeting at the main entrance of the business of the commission or council, and post notice to our website. During COVID, the prominently display at the main entrance has been done away with because we can't do in-person meetings. Members can waive notice of the meeting if they attend or they do a written waiver. And the one thing about special meetings that's different than regular meetings is that in a special meeting, you can only take action on items that are listed in the notice. In a regular meeting, we can add items, assuming that there's not a public notice requirement that says that you have to do a 10-day notice for this action or a 5-day notice for that action. But if it's an item that doesn't require notice, as an example, approval of a contract, there's no public notice requirement for that. So you can add agenda items to a regular meeting, even at the time of the meeting. Meetings held exclusively by telephone. Again, this is a little bit, this slide kind of goes back to the days when this was a little bit less common than it is today. But there is Attorney General opinion saying that it's permissible to do a meeting exclusively by telecommunication, and that what we do have to do is enable the public to participate and attend now in the virtual meetings that we hold. Used to be that we would have at the city hall or the place where the meeting is occurring, we'd have a speaker phone where the person who's attending by telephone, you could hear them over the phone and they could hear you. So that it used to be that you have to have a physical location where people can come to and hear what's being said over the phone. And now it's all been sort of taken over by Zoom and GoToMeeting, and we give the notice and we give the opportunity for people to participate that way. So again, on regular meetings, I said a moment ago that we can add matters to an agenda at the last minute. That's true. There is a statute, this is at the bottom of the screen there, that says that you are to post your regular meeting agendas online at least 24 hours in advance of the meeting. The agendas may be amended after the posting. So even though you've done your posting, if there's something that needs to come before the body at the at the last minute or not in time to have done your 24-hour posting, it's okay to go forward with that. The statute provides that failure to post the agenda item doesn't invalidate an otherwise legal action. So we do have executive sessions. Those are specified by statute. Let's talk some of the more common grounds for executive session are consideration of the acquisition of real estate, where public knowledge of the location or price considerations of the real estate are likely to result in a higher price being paid. So in that case, you can consider the acquisition of the real estate in executive session. Same thing with the other side of the transaction. If you're selling or leasing real estate, you can discuss those items in executive session that will affect or are focused on the price. So there's a case recently having to do with the Port of Vancouver. You may be familiar with the case. It had to do with the oil terminal and a consideration of a lease to the company that was going to operate the oil terminal. And the port held some executive sessions to discuss the lease of the terminal. In fact, they invited the potential lessee to the meeting, at least one of the meetings. There were several. And they, in the different meetings, discuss a whole range of things, including environmental considerations, insurance, and the Supreme Court ended up holding that those discussions that were not focused on price had to occur in an open session. And of course, the final decision on either the acquisition of real estate or the leasing or sale of real estate has to be done in an open meeting. Another reason for executive session is to evaluate charges against a public officer or employee, to evaluate the qualifications of a applicant, or to review the performance of a applicant or an employee. So number 4 is focusing on people applying for jobs or how they're performing their jobs. That can be done in executive session. We recently just did evaluation of qualifications of candidates for appointment to elective office. So council's very familiar with this process, where we can, in executive session, talk about qualifications of a candidate, but the interviews and the selection of the candidate has to occur in the open public meeting. Number 5 is missing on this slide, but that's to evaluate complaints or charges against a public officer or employee. Number 7 is to discuss with legal counsel an enforcement action or potential litigation. And potential litigation is actually defined in the Open Public Meetings Act. It's not just any what if, maybe somehow we could get sued. It's limited to claims that have been specifically threatened or which the agency reasonably believes may be commenced. And like I said before, labor negotiations are not subject to the Act. So a word about the process of going into and out of executive session. To go into an executive session, you have to first meet in an open meeting. And then from your open meeting, you announce that you're going into the executive session. You state the reason why you're going into the executive session, how long you're going to be in executive session, and then you come out of the session back into open session. And if the executive session is taking longer than you expected, it's permissible to come back out, announce in the open session that we're going to extend the executive session and resume the executive session. In stating the reasons going into the executive session, you do have to be somewhat specific in terms of stating that we're going to consider the lease of real estate. You just don't, it's not permissible to simply say, we're going to discuss a real estate matter. Or probably the most common thing that's done not technically correctly is to say we're going to go into executive session to discuss personnel matters. There isn't an executive session for personnel matters generally. Again, you would need to say we're going to discuss a complaint against an employee, or we're going to discuss the performance of a public officer or employee. But simply saying personnel matters is not sufficient. So a word about what's done in the executive session. What you discussed there is just that. It's confidential. There's an attorney general opinion on the issue. You have a legal obligation not to discuss publicly information that was discussed in a executive session. Disclosure of this confidential information is a violation of the Code of Ethics of Municipal Officers, and it could constitute a misdemeanor offense or official misconduct, both of which are criminal, and it can be grounds for forfeiture of office or grounds for recall. So what do we do? What happened? If we took an action in a closed meeting, now what happens? One of the things that's looked at, if it's brought to a court's attention, is they want to know whether or not it was an unintentional violation. Even if it is unintentional, it can result in the nullification of the action and the imposition of attorney's fees and costs. If it's a knowing violation, the act provides for personal liability of the members of the council or the commission. So if you knowingly participate in a meeting that is required to be open to the public, you can be subject to a fine. It's a $500 civil fine for the first violation and a $1,000 fine for any subsequent violation. And again, just like we looked at in the previous slide, on executive sessions, knowingly, intentionally violating the Public Meetings Act can result in official misconduct, potential forfeiture of office. So that's sort of the punitive side of what happens if there's a violation of the Open Public Meetings Act. Let's talk for a minute about what do we do if we did? How do we fix it? So curing an Open Public Meeting Act violation, you can fix it. Later action that's undertaken in compliance with the act will cure the violation, but the subsequent action, it must be open and otherwise conform to the Open Public Meetings Act. It can't be just a summary approval of the earlier action. So taking, for example, the Port of Vancouver and the lease of the terminal, they had to go back and conduct a meeting in open session and hold the discussion on everything except for price in the Open Public Meeting Act, Open Public Meeting, where the citizens could observe it and provide testimony. So you just got to go back to sort of the beginning and take the action and hold the meeting in compliance with the act, and then take your action, and that will be a legal action. But just approving it on a consent agenda without any discussion, where, if it's an item that required public testimony, open consideration, you can't just say, well, we just reapprove what we did before. There has to be that opportunity for community and opposing party input. So that brings me to the end of my discussion of the Open Public Meetings Act, and I'd like to open it up for any questions.
Can you guys hear me?
Yes.
Hey, Bronston. I'm not sure if you got my email, but I was just curious if if the CAD files that a consultant prepared would be it fit within the Telford test that you mentioned earlier for the public meetings applying to consultants.
No, Sean, actually, I'm going to get in contact with you about your public records request, if that's what you're referring to. So no, that's not part of this OPMA discussion.
Okay, I apologize. There was just a coworker that was asking me about that, and I've been trying to educate myself more on it too. So I apologize if it's out of the scope here.
Yeah, that's fine. No, that's okay, but it is, yeah. Any other questions?
Bronson, this is Dennis.
Yes, go ahead, Dennis.
Question regarding the fines and such. Those are go beyond that of just executive session, correct? That includes everything. In other words, they weren't applicable just to executive session it's material or discussion.
You're correct. That it's not just limited to considering matters in executive session that should be an open session. It's for any violation of the act. And so there's a case out of the Battleground School District where members of the school board engaged in that email exchange that ended up involving a quorum or more than a quorum of the board. And that was subject to, that was a violation of the Open Public Meetings Act. It could have resulted in those fines for those individual members, but in that case, the court said this wasn't a knowing intentional violation and we're not imposing fines. But they can be imposed for any violation of the Open Public Meetings Act. That's a good point.
Thank you, Bronson. One other question, if I might.
Yep.
The mayor has held, prior to COVID, a monthly mayor town hall, usually held at Public Works. And his last one was done virtual. My question is, in that situation, the attendance of 2 or more council members in that mayor town hall meeting, which is open to the public, what is the situation there?
Good question. So the attendance of other council members, even if you end up having a quorum and participating, let's say in the virtual meeting, that is not a violation of the act. And let's go back to, it's not just being present, but it's you have to take action, and that action includes discussion or consideration among the members of the council or commission. So if there's, let me just use a hypothetical. The mayor has his town hall and 2 council members are attending, but they don't say anything. They're just listening. That's not a violation of the act because all that they're doing is that passive receipt of information, which is not action. But if they then start, if the other council members begin commenting and talking during the town hall meeting, and now they're engaging in a discussion and consideration, and you end up having, a quorum, the mayor and 2 council members, all discussing city business in the town hall meeting, that is a meeting, and it's open to the public because the public was notified of the town hall, I assume. And, so if it's open, not a violation. But if there's no notice, if it's done in a context where only some people, haven't been notified about it, and you have discussion, that would be a violation. So what I would suggest is that for those types of meetings, you could do a special meeting notice if you know that there's going to be a quorum present and they want to be involved in discussion and consideration. You can avoid any violation by just providing a meeting, special meeting notice. Any other questions?
I don't have a question. This is Dinah, but I did want to mention we have 10 minutes until the Planning Commission meeting starts.
Okay, thank you. So let's go on to the Public Records Act. And the Public Records Act was enacted in 1972. It was an initiative by the people of the state of Washington, where 72% of the people voted in favor of the initiative. And like the Open Public Meetings Act, the message was similar. It was that the public has the right to know and decide what's good for the people, and to know what their representatives are engaged in their business. Agencies have to make documents available for inspection and copying unless there's a specific exemption. And during COVID, of course, there's been a suspension of making records available physically for inspection and copying. One interesting thing about the Public Records Act is that there's no particular form of request that's required. You need to honor requests, whether they're received by mail or by email or even verbally. We encourage people to put their requests in writing so that there's a record of what specifically they asked for, but a request can be done verbally. Another thing is that you don't have to, when you request a public record, you're not required to state why you want the record. The only limitation is that you cannot ask for a public record for a list of individuals if you want them for a commercial purpose. So in responding to public records requests, you get the request, you initially have a 5-day period within which to respond. Again, right now with COVID, the 5-day response applies to requests you receive electronically, but it doesn't apply if you receive the request by mail. The response could be either you provide the record, or you provide a reasonable estimate of time of when you will provide the record, or you can ask for clarification of what it is that's being requested. A request for a public record has to request an identifiable record. So it's frequently necessary to seek clarification so that you can try and narrow down what it is specifically that's being asked for, or you can deny the request. You can provide records in installments if they're voluminous. You can either wait till the end and give them, here's all the records you requested, or you can provide them in installments, which I think is the better practice. If you don't provide a record, if you're claiming that it's exempt, you need to provide a log saying, we're not providing this record because this exemption applies, and here's the reason why. And there's also a provision where if someone's requesting a record and you think that there's a third party who may have an interest in the record not being disclosed, you can give that third party notice, and that third party has the right to go to court and try and prevent the disclosure of the record. But it's important to distinguish between a request for a record and a request for information. Sometimes I'll give you an example. You might get a request saying, I want to know for this particular intersection, I want to know the direction from which traffic is going when there was a collision for a 5-year period, and how many people were going east, west, north, or south. They're asking for information. You don't have to go through records and pick out information and then provide the information. It's a request for a record. So the person says, I want the accident reports from the intersection for 5 years. You would provide them with the accident reports. But the Public Records Act does not require you to sift through records and do an analysis and provide information. So let's be more specific. Public records are defined. It's any writing, regardless of its form or characteristics, that relate to the conduct of government and are either prepared, owned, used, or retained by the agency. So the questions, about whether something is a record or not, typically it's not about whether it's a writing. It can be, electronic, it can be physical hard copies, but it's really the issues become to whether it relates to the conduct of government and was it prepared, owned, or used by the agency. Public records on personal devices become problematic. So something to be a public record, it doesn't really matter if it's stored on a public server or if it's stored on your personal laptop or phone. So if we're talking about a personal device and you've got information relating to the conduct of the city of business, and if the record was created within the scope of the employment, which is either the job requires it or the employer directs it or furthers your employer's interest, that record is a public record and it's subject to disclosure unless an exemption applies. So what do we do if there's a request for a record on a personal device? The agency does not have the authority to seize the personal device and perform a search. The courts say we're going to balance the right of privacy against the right and obligation of disclosure. And what we're going to do is we're going to make the person who owns the personal device conduct a search and describe in a sworn affidavit or declaration. They have to describe how they conducted the search, what they found. If it's a record, a public record, disclose it and provide that declaration and those records to the agency. So public record response is very expensive and you're very limited in what you can charge for the time and effort that goes into responding. You can't charge for inspection of records. You can't charge for the time that it takes you to search for the records and prepare them for disclosure, such as having to redact certain parts of the records. There's a statutory fee schedule that applies, and it's like 15 cents a page for printed material, 10 cents a page for scanned. It's pennies on the dollar of the cost to respond. Talk a bit about exemptions. There's at least 46 exemptions to disclosure in the Public Record Act. And then the Act also has a provision that's called the other statute exemptions. So you'll find exemptions from disclosure in other state and federal laws that aren't in the Public Records Act, but those apply as well. And examples are information on license plates, information on criminal records. Those exemptions are not in the Public Records Act, but they are in the Criminal History Act. And so there's just a broad array of exemptions that goes way beyond the scope of this training. But what the courts will do is they will say, this act is intended to require disclosure, and we're going to enforce the duty to disclose broadly, and we're going to interpret the exemptions narrowly. And there isn't any general privacy exemption under the Public Records Act. There is a specific invasion of privacy exemption if the material is highly offensive to a reasonable person and there's no legitimate concern in the information to the public. But the violation of the right to privacy is a theme or element of several exemptions, such as personal information maintained in an employee file. Recently, the legislature specified the types of personal information that's exempt. We don't need to go through that detailed list, but it includes photographs, dates of birth, that type of thing. So if you get a request for a record and it's exempt, often the record includes exempt material and some material that's not exempt. And so what you're required to do is black out or redact the part that's exempt and provide the part that is not exempt. And then if you're claiming an exemption, you provide a log saying this is redacted for this reason. There's the state archivist provides a schedule of how long you have to keep records. It's a good practice that if you have exhausted the retention time to dispose of the record, you can delete it, you can give it to the state archivist to keep for beyond the retention period. But if there's a pending records request, you cannot delete a record that is subject to the request. You have to keep it until you've satisfied the request.
Hi, this is Dinah. I just wanted to, I see a few people joined. I just wanted to announce that the Planning Commission will be starting a few minutes late as we're wrapping up this discussion on Public Records Act and the OPA. Thank you.
Okay. Some of the things you can do to manage the risk of inadvertently not being able to produce a record is you can have dedicated email accounts. So you use your city email account for your city business. Sometimes you can use a device provided by the agency, so a phone. If you're going to be doing text, have a city phone separate from your personal phone for doing that. You can disable some features, just don't text. But it's important that you be consistent so that if you do get a request, you know what your practices have been and how you keep the information, how you'll be able to recover it and produce it. Again, the state archivist has rules on destroying or transferring records, and we need to comply with those. Last slide is on enforcement and penalties. If there's a violation, the courts can impose statutory penalties and award attorney's fees. Oftentimes the attorney's fees exceed the amount of any penalties. The court can order disclosure of anything that's withheld. What your obligation is to make a reasonably adequate search for a record. The courts and the Act do not require perfection, but they do require that you make a reasonably diligent search to provide the records requested. And if you somehow missed one, that doesn't mean that you necessarily violated the Act, so long as you acted reasonably and you can show how you conducted your search and that the way you went about doing it made sense. So, questions on the Public Records Act? Okay, thank you.
Okay. I just want to thank the city attorney this evening for providing training to both the city council as well as the planning commission. I apologize to the guests this evening for the planning commission meeting. We did run a little bit late. I appreciate your understanding. And with that, I just want to wish everybody a great evening and thank you again, Bronson, for the training.
You're welcome.
Thank you.